Hi all. First wanted to thank Andrew for inviting me to present to your class. And I really wish that this was an in-person presentation because this seminar is such a cool and topical and important topic. I reviewed your syllabus and realized that you've covered actually quite a broad array of topics at the intersection of AI and law. And some of these are actually quite interesting to me. So it's great to see that you're getting an introduction to areas of legal research and writing, and even leading cases in areas like tort law through reading Donahue and Stevenson, and the risk of wrongful convictions in your readings of the Marshall case. I also see Daniel Citron and Bobby Chesney in your syllabus, and they're really presenting some cutting edge analysis of online harassment and deep fakes and hate speech. So that was also cool to see in your syllabus. And Andrew mentioned that some of you may be interested in applying to law school and that it would be helpful to hear about my path to law school. And I'm in second year here at Allard. So I think it will help you to also understand the perspective that I bring to the questions at the intersection of AI and law. I have a computer science PhD from UBC. My PhD was focused on computer vision or artificial vision, and I improved and experimented with a model for object recognition. And object recognition is the problem of asking a computer to identify what things are in an image or in a video. But notably, I was not using deep learning. I was using a model of computer vision that was popular throughout the 2000s that was based on human engineered features. But I did get to witness the resurgence of neural networks starting in about 2006 and the rise of deep learning starting from about 2012 onward. I did get to apply deep learning techniques in industry and in industry based research. At Google, I worked on a system to automatically tag videos based on their visual content. And at Shelfie, a Vancouver based startup, we used deep learning as part of a computer vision system that would identify your books in photos of your bookshelves. And that identification was based on the visual appearance and on character recognition. And at Kobo, a Canadian e-reader and e-book retailer, I worked on deep learning based recommendation systems. But what brought me to law school? I found that I just wasn't happy with the problems that I was getting to think about in my day to day work. While they were super interesting and stimulating, I wanted to feel like the work that I was doing was more directly helping my community. And one of my concerns was for people that don't have an adequate voice in our legal system, in our political system in general. And I wanted to be part of fixing that. And you can do that work from either side of the government public divide. In public interest law, or civil liberties, or immigration law, for example, just holding the government to account when it misuses its powers, or from within the government, to do your work fairly to best represent the democratic will of the people, while at the same time helping to give people confidence in the outcomes of the legal system and government decisions in general. So one of my interests in the topic of this presentation is public law accountability when the government uses AI or algorithmic decision making in its decision making process. But first, what is an algorithm? An algorithm is just a sequence of instructions which take input and produce an output. And generally, that's assumed to be running on a computer. For example, it could just be a simple flowchart-based process that's been programmed into a computer. A person could follow that, but it would be tedious. Another example would be a linear model that combines input variables or factors based on human-specified or machine-learned weights or multipliers. Again, a person could do this, but it would be fairly error-prone. And because they're linear models, it would be fairly obvious what factors such an algorithm would be treating as significant. A third example, the most complex algorithms used for decision making are deep neural networks. These have millions of parameters. These are weights or multipliers that are tuned automatically by machine learning. And the relationships between the input features and the output predictions are opaque and unintelligible, even to the algorithm designer, also to the person who coded the software, and to the person who trained the system. So which of these models is it fair to call an artificial intelligence or an AI? I don't actually find it very useful to define artificial intelligence for the purpose of evaluating the legitimacy of algorithmic decision making by the government. A computer that does something, that makes a decision, produces a prediction, classifies something, or takes an action, that's the distinction that's important here, that it's something other than a person who has made that decision or taken that action. It's also important to understand the source of legitimacy for Canadian public law power. And ultimately, that power does come from us. And that's conferred on our legislature, our MPs, members of parliament, uh, by us when we democratically elect them. Subordinate to the legislature is cabinet, and cabinet is responsible to the legislature. This might be a bit of an illusory oversight, though, in that cabinet is almost always, without exception, drawn from the legislature and formed from the majority of the MPs in the legislature. So, despite it being responsible to the legislature, it often controls the government in both the branches. And all the actions of the executive, the cabinet, need to be authorized by the legislature. In order to hold the cabinet accountable, legislature can end a government. They can require an election. Usually, because the cabinet is drawn from the majority of the legislature, this isn't an effective check on the action of cabinet. So it's often through the courts that your rights can be vindicated. When you question whether the executive branch of the government is exercising properly delegated power, a person can go to a court and say the government didn't have the power to do X. And this is the institutional structure that's behind the questions that we'll be looking at in this seminar lecture. When an executive branch agency makes a decision using an algorithm, the question is often, is it doing that with the authority of the legislature? Is it exercising power within the limits set by the legislature? Is it compliant with the charter? And how would you know? So where does algorithmic decision making actually arise within the government? You've already looked at examples of algorithmic risk assessment for sentencing in the US, but let's look outside the courtroom to the executive branch. Where do you think it might be happening? If you were the government, where would you be deploying algorithmic decision making? And I want to point you to the report on the slide here by Petra Molnar and Lex Gill titled Bots at the Gate. This is a really nice case study looking at various applications of algorithmic decision making in production or in development or exploration by the Canadian government. So I'll just list some examples that they present. Immigration, Refugee, and Citizenship Canada is investigating predictive analytics to automate activities that are currently conducted by people, immigration officials, and to support their evaluation of an immigrant and visitor applications. The Vancouver Police Department uses predictive policing to inform officer deployment for property-related crimes. There is something called limited entry hunting authorizations. Certain animals in British Columbia, if you want to hunt them, you need to enter a government-run lottery, and that lottery is run by an algorithm. It randomly prioritizes all entrants, accounting for which types of animals they've requested to hunt, and lowering the chances for people who have received an authorization in the past. The Canada Revenue Agency uses predictive analytics to address non-compliance, and that could be something as simple as anomaly detection, just like banks and credit cards use anomaly detection to detect fraudulent transactions. And those signals could raise a red flag for the CRA to undertake a more thorough review of that person's file. Also in Project Wide Awake, Canada's RCMP uses software for proactive identification of crimes based on internet behavior, public internet behavior. And this isn't technically an administrative decision. It's not a final decision that affects your rights and your interests or privileges, but it does guide police scrutiny. It guides their scrutiny in their pre-warrant investigative activities. and it can increase police presence at certain activities or those of certain communities. And if correlation of police presence is based on irrelevant factors, that can be problematic. So that's a large list of examples, and some of them might seem to you much more innocuous or more problematic than other examples. And your instincts there are probably related to what you consider the rule of law to mean. Um, so to tease this out a little more exactly, to figure out what does the rule of law mean to you, um, and what does it mean to Canadian public law, here's an example. Imagine you apply to the BC Liquor and Cannabis Regulation Branch for a special occasions license. This would let you serve alcohol at a private event. What are your expectations about how that decision would be made and what the outcome would be? What if they made this decision by flipping a coin? Or what if they delegated the decision to the neighbors of the venue where you want to hold the event? Could they just adopt a policy that all applications that come in on a Thursday are rejected? Or what about a policy that no licenses will be granted to Catholics? So the reason why some of those decision-making processes seem problematic to you are because of your instincts about what the rule of law means. And to outline some of its content that Canadian courts have given to the rule of law. First, the power of an agency and of an executive agency has to be prescribed by positive law. It needs to be enacted by the legislature, written down, and that defines the power and the responsibilities of an executive agency. So it actually is the BC Liquor and Cannabis Regulation Branch that's responsible for this licensing. It's not the neighbors of the venue. Unless you find in the statute the power for this liquor branch to delegate that decision to the neighbors of a venue, it's the branch itself that needs to make that decision, or the delegate within the branch that's statutorily authorized. Second, why can't you flip a coin? Again, unless the statute prescribes that's how the decision is to be made. There's an assumption against non-arbitrariness at the heart of the rule of law. And it assumes consistency, legal certainty, and formal equality. And this is why a decision that's based on the day of the week that the application is filed or on the person's religion are equally problematic. So one more concrete example. This is an actual part of a statute from Newfoundland and Labrador, the Fish Inspection Act, and it says the following. The minister may refuse to issue a license required under this act or the regulations without assigning a reason for the refusal. Now, this is a very broad grant of discretion. Reasons are not even required. The minister can just say yes or no. But that power isn't completely unconstrained. It is still limited by some of the rule of law principles that we just went over. The minister can't make the decision arbitrarily, in the sense that the decision has to be made by considering the factors relevant to the purpose of this policy. The minister can't make this decision on bad faith, so for a reason irrelevant to the purposes of the policy. But you can see that even in the case where a person is making this decision, challenging such a decision would actually be quite difficult. How would you demonstrate bad faith in the absence of reasons? How could you demonstrate that the minister considered an irrelevant factor in the absence of reasons? This all just becomes heightened in the context of an algorithmic decision maker. So I'll move now to some categorizations of the dangers or the problems behind using algorithms in high stakes decision making. And I'll present two taxonomies, one by Andrea Ross from a paper called Machine Testimony, and she calls these the black box dangers. And the first is human-caused falsehood by design. And this is an example where the engineers intentionally designed an algorithm to tell a lie. And a really popular example or a prominent example recently was the Volkswagen emissions reporting. The engineers designed the Volkswagen to detect when it was in an emissions testing environment and operate differently than it would on the road. The second is inarticulateness. And this is just a limitation inherent to many machine learned models, the inability to actually describe any of the internal logic of the decision making process. The third is human caused analytical error. These are bugs. Perhaps the programmer didn't consider that the input form would contain any characters with accents in them, so it stops reading the input upon the first accented character. The fourth is machine-caused analytical error, and this would be a machine learning model that overfits or attends to irrelevant factors, or using an algorithm that's not trained for this particular problem. And last, operational error. And this is where the frontline user of the trained algorithm just happens to input data incorrectly or misread the output. Another taxonomy, overlapping to an extent with the previous list, are the algorithmic risks presented by Molnar and Gill. And they're the authors of the Bots at the Gate report I showed you earlier in this presentation. So the first is a lack of reasons, and this is exactly the same issue with the inarticulateness mentioned by Andrea Roth. Neural networks in particular are inherently difficult to understand. The second is anchoring, and this is when a human is aided by an algorithmic decision that either flags a file for review or produces a preliminary decision. It can result in the human not being willing to stray from that initial algorithmic prediction. The third, the guise of neutrality. And this is the fallacy of assuming that because a computer is making the decision, that the decision is objective, free from bias, and not attending to irrelevant factors, that you can trust it. This is related to the next two risks, precision being mistaken as accuracy. The computer is going to produce a precise prediction. If it's a score, for example, that might have many decimal places after it, and that should not be mistaken for an accurate result, just because of its precision. And the last risk is the risk of feedback loops, that the algorithm is just reinforcing existing bias that was present in the training data. Algorithms are trained by using machine learning to tune the algorithm's weights, its parameters, so that it performs well on the training set. It takes training data and adjusts the parameters of the algorithm so that it's producing correct predictions on that training data. And that's all the algorithm is attempting to do. And what does it mean to get to make a correct prediction on the training data? It means to reproduce the predictions that were made by humans in the past. So just to review, what we covered so far is the structure of power in Canadian law, and the source of power for our executive government coming from the legislative branch, that it's conferred by, and its powers are confined by, the acts of the legislature. It's also confined by the constraints of the Charter of Rights and Freedoms. Next, we looked at what the rule of law means in Canada, and its assumptions of non-arbitrariness, that powers of the executive are conferred in positive law passed by the legislature, and assumptions of fairness and non-discrimination and formal equality. And then we looked at how algorithmic decision-making can pose problems, both for fairness, accountability, and explainability. For the rest of this presentation, we'll look at proxy discrimination, counterfactual explanations, and a directive from Canada's Treasury Board that addresses how algorithmic decision-making can be deployed in the Canadian government. Proxy discrimination is related to the fairness concerns that we've talked about, and the counterfactual explanations are related to the explainability or understandability, transparency of the decisions. Proxy discrimination is a concept recently explored by Anya Prince and Daniel Schwartz. And proxy discrimination they describe as a form of adverse effects discrimination that indirectly distinguishes based on protected characteristics. while not using any of the protected characteristics as a basis for decision making, an algorithm will learn how to make best use of the available and permissible features. And when the protected characteristics happen to actually be predictive of the desired target prediction, the machine learning algorithm will learn proxies for that prohibited characteristic. And this is exactly the issue that you saw when you were looking at the compass data, the recidivism data as part of the sentencing decisions. There's no race encoded in the data. That isn't one of the fields, but other aspects of the data are certainly correlated with race, and that compass algorithm will pick up on those correlations, use those features to make predictions about recidivism, and ultimately is making distinctions based on race. And the authors, Prince and Schwartz, situate proxy discrimination within the universe of discrimination in general. They first make the distinction, this is a distinction recognized in US and Canadian law, between disparate treatment discrimination and disparate impact discrimination. And those are US terms, so I've written the Canadian equivalents below, but they're analogous concepts. In Canada, these are referred to as direct discrimination and adverse effects discrimination. Direct discrimination being discrimination that on the face of the statute or the intended effect of the statute is to actually discriminate on the protected ground. Whereas disparate impact discrimination or adverse effects discrimination, it isn't apparent on the face of the statute or the policy, nor is it the intended purpose of the policy to discriminate on the prohibited ground or protected ground, but it in fact does. For example, a test based on strength may discriminate, may have a disparate impact on women, or using a credit score may have a disparate impact on people with low income, assuming that income is a prohibited characteristic. One concrete example is redlining, and this is on the disparate treatment or direct discrimination side of the line. This is a policy by banks and local governments to deny people applying for grants or loans from certain geographic areas. And this had the intended effect. Its purpose was to deny those loans and grants to Black people. On the other side of the line is the example given here, insurers using credit scores as a proxy for income. And this is, in this example, an unintended proxy. All they're aware of is that credit scores are predictive of insurance risk. It isn't that they've recognized that what they want to do is actually discriminate based on income, and as a way to do that, using credit scores to do so. Their target is insurance risk, and they're using credit scores because it's predictive of insurance risk. Unbeknownst to the insurer, it's also a proxy for income. And I should add, in that example, it's assuming that income is a ground that insurers are prohibited from discriminating on. So how can we design and deploy an algorithm in a way that avoids this risk of proxy discrimination? Prince and Schwartz point to several solutions, and I'll dive into two. The first is using the algorithm itself to protect against discrimination, to enforce the anti-discrimination goals that we've set out. And the second is a transparency-based approach that reveals more information about the factors that the algorithm is relying on. So one algorithmic approach to explicitly learn anti-discrimination involves actually collecting information about the protected trait as part of the training data. And the algorithm would extract a set of features from the non-protected traits, from the permissible variables, that are predictive of the desired target variable, the insurance risk, for example. But in parallel to that, there's a second algorithm using those extracted features to try to make predictions about the protected trait. And success in this regard would be if the extracted features are predictive of the target, but give no information to that secondary classifier about the protected trait. If successful, the feature extractor has extracted features that are not correlated with the protective trait, yet are predictive of the desired target variable. Another of their proposed solutions is a emphasis on transparency, and this would require disclosure of the inner workings of the algorithm, or even just the simple fact that there is an algorithm making a decision for you. And the work on counterfactual explanations assumes as a premise that algorithms will be a black box. And this might be because of their proprietary nature, or just practically they may be uninterpretable. The people subject to them may not have the necessary background to really understand, um, even if reasons were able to be given based on the internal workings of a deep neural network. So instead of seeking to explain the inner logic, a counterfactual explanation, and I'll give an example next year, seeks to further understanding, give an explanation that the subject could use to contest the decision, and information to help the subject understand how to act in the future or how to change their circumstances in order to obtain a favorable decision. So, as an example of what a counterfactual explanation would look like, here's one on the slide. You were denied a loan because your income is 30K. If it were 45,000, you would have a loan. The claim is that this is enough information to give you an understanding of what this algorithm is doing. It may give you grounds to contest the decision, and it lets you know what you might do differently in the future, or how you could change your circumstances so that when you reapply, you'd be given the loan. But in this example, the word because, it's doing a lot of work. It's hiding a lot of ambiguity. It may very well be conflating a contributing cause, this income, 30K, 45K, with a necessary and sufficient cause. At most, these counterfactual explanations are revealing that it was a factor in the logic. And if you change that factor, you would be in a different position. The proponents of the counterfactual explanations recognize that there isn't a single counterfactual. There's often several counterfactuals. It might be your income. It might be your work. It might be the purpose for the loan. It might be a cosigner. Many factors could be presented as a counterfactual. So to narrow the range of the options, the authors focus on finding the closest possible world that would result in a different decision. So counterfactual examples are perturbations to a data sample that would result in a different classification. And people play around with counterfactuals as adversarial perturbations to images as they explore the behavior of an image classifier based on deep neural networks. So for example, given an image that's currently being classified as a panda, for example, by a deep neural network image classifier, there are other algorithms that will perturb that panda image with a small amount of changes to each pixel across the entire image, such that the classification changes, in this case, to a 99.3% confidence that this panda is a gibbon. These changes are made across the image, pixel by pixel, but in a way that is imperceptible to a human observer. In aggregate, this new image is classified as a gibbon, but if you look at the actual characteristics of this image, because of the changes in the pixels, this isn't an image that would actually be produced by any imaging process combined with JPEG compression, for example. This is an image that couldn't be created in the real world. It's only creatable through this perturbation process. And a similar problem applies to counterfactuals. For a counterfactual example to be useful to someone that has been subject to a decision, the counterfactual needs to be actually possible for that person. But regardless of that limitation, proponents of counterfactuals claim that they are sufficient to help a person subject to a decision to understand that decision, to help them contest that decision, or to alter their future behavior to obtain an alternate decision. So counterfactual explanations may be sufficient under a regime like the GDPR, in which someone subject to a decision merely needs some information that a decision was made using an algorithm, and information about the input variables, their sources, and why they're relevant to the decision. The GDPR doesn't require a complex explanation or revealing of any internal logic of the algorithm, just some information, general information about the decision-making process. Counterfactual explanations may be sufficient for that. But in the context of Canadian administrative law, the requirements for reason giving are different than the requirements for information and notice under the GDPR for algorithmic decision making. The purposes of reasons in Canadian administrative law are different. The Supreme Court has said that the purpose of reasons is to explain how and why a decision was made, to show the person subject to the decision that they've been heard, and to broaden the mind of the decision maker. By providing reasons, it focuses the decision maker on public-focused purposes. So while counterfactual explanations can reveal some information sufficient for regimes like the GDPR, which require mere information and notice of a decision being made by an algorithm, they seem like they would be insufficient for the purposes of Canadian administrative law. They don't provide internal logic. They give no evidence that you've been heard as someone subject to a decision. And they don't at all affect the mind of the decision maker. There is no mind of a decision maker in this case. And the Canadian government has recognized that. The Treasury Board has issued a directive to the Canadian government on automated decision making. And I'll switch to that right now. And this is a directive to any actor in the Canadian government using artificial intelligence to make automated decisions. And I'll just scroll through this and point out some of the highlights. I'll first stop on the scope. Notably, it applies only to systems providing external services. So this wouldn't apply to tools that simply flag a file for review, for example. And it also doesn't apply to any national security system at 0.5.4. The requirements on an agent of the government using an automated decision-making system are that an algorithmic impact assessment needs to be completed, and that slots the impact of the automated decision into one of four categories, one being the least onerous on somebody subject to the decision, four being the most. Depending on the potential level of impact, there are different requirements of transparency and quality control. Transparency requires that notice be given to someone subject to an automated decision that they will be subject to an automated decision. Explanations need to be provided after decisions, and this is a meaningful explanation. When the government owns the source code, unless it's top secret or protected, the government's committed to releasing that source code, to disclosing it. And the Treasury Board has directed measures for testing and monitoring, data quality, validating the data, keeping it up to date, and allowing for peer review. And here are the four levels of impact. Level 1, the decision will have little to no impact on the rights, the health or well-being, economic interests, or the ongoing sustainability of an ecosystem. And these will often lead to impacts that are reversible and brief. Moving up, level 2, decisions will have moderate impacts on those factors and will often lead to impacts that are likely reversible in short term. Moving on up, level 3, high impacts, impacts that will be difficult to reverse and are ongoing. Level 4, very high impacts, leading to impacts that are irreversible and perpetual. And so just looking at peer review, you can see the difference required between a level 1 impact decision and a level 4 impact decision. A level 1 impact decision requires no peer review. Level 2 starts to require review from qualified experts. Level 4 requires review from experts from particular agencies, from the National Research Council, Statistics Canada, for example, university university members, qualified members of faculty or of a post-secondary institution. Notice requirements similarly get stepped up as the impact increases. For a level 1 decision, no notice needs to be required. Level 2, plain language notice. Levels 3 and 4, documentation about the automated decision in plain language describing the components, how it supports the decision, any reviews or audits, and a description of the training data, and even a link to the anonymized training data if it's available. Level 1 and 2 impact decisions can be made without any direct human involvement. Levels 3 and 4 decisions cannot be made without human intervention. The explanation requirement is also scaled across the impact assessment levels. For a level 1 decision, you didn't even need notice that an algorithmic decision was being made. So similarly, there's a low bar for the explanation that you need. It can be provided in an FAQ on the website. Levels 2 and higher decisions, though, need meaningful explanations provided on request for the particular decision that denied you a benefit, a service, or other action that you were seeking. But notably, all of that was just a directive from the Treasury Board. The Treasury Board is part of the executive. So this is, in a sense, the executive telling the executive setting a policy for itself about how it's going to employ automated decision making. This isn't a constraint provided by the legislature. These steps that the Treasury Board has directed the rest of the government to take, no court has said that those are sufficient steps for notice and reasons required by someone negatively affected by a decision. So there is a void here. The legislature hasn't directed explicitly authority to take decisions by using an algorithm. They haven't constrained the executive from using algorithms, and the court has not provided a lot of guidance about what would be a sufficient explanation from an algorithmic decision.